Welcome to the Far and Beyond podcast, hosted by the Contracts and Fiscal Law Department at the Judge Advocate General's Legal Center and School. This podcast is for the federal government attorneys navigating the complex intersection of acquisitions and fiscal law and policy. I am your host, Major Ellie Sewell.
I'm Major Ed Callahan.
And I'm Major Jason Floyd. Together, we're your co-hosts. On this episode of The Far and Beyond, we're continuing the theme of cybersecurity to talk about the Federal Acquisition Supply Chain Security Act, or FASCSA. After years of framework development, the government has finally dropped its first FASCSA order.
So for many of us, Jason, the FASCSA has been a regulatory concept, but now it seems like it's becoming an actual thing that we have to deal with on a day-to-day basis.
Exactly. To help us navigate this new landscape, Jason is going to walk us through. All right, let's start with the basics. What is the Federal Acquisition Supply Chain Security Act, and why is the recent order so important?
So that act, codified at 41 U.S.C. 1321 through 1328, is the statutory framework the U.S. government uses to mitigate supply chain risks, primarily in what's called Information and Communication Technology Services, or ICTS. The FASCSA established the Federal Acquisition Security Council, or the FASC, which is an interagency body tasked with evaluating threats posed by certain suppliers, who we call sources, and their products, which are called covered articles. The ODNI, or the Office of the Director of National Intelligence, made public an order in September 2025 to label a company called Acronis AG as a source, meaning all the products that they offered have to be removed at all levels of the supply chain for all DoD contracts.
All right, Jason, so the FASCSA is codified under 41 U.S.C., which isn't inherently a Title 10 authority that we have to deal with on a day-to-day basis.
That's right, Ed. Do you know what Title 41 is?
I don't.
Public contracts.
Oh, look at that. I should know that. Let's pretend I do know that for the future of this podcast.
Yeah, so Title 41 applies to the entirety of the federal government, right? There are exceptions, right? So Title 10, there's exceptions to Title 41, but generally when we're talking about federal public contracts that apply to the executive branch, we're finding that info in Title 41.
Okay, so that's interesting. So based on that, what exactly would a covered article be as far as we're concerned? Like, how far does the FASC's reach go within the Department of War?
Yeah, so it's pretty broad, right? And the Secretary of War does have a statutory role in there. We'll get to that, though. But yeah, so the scope of the act itself is intentionally broad. It's to capture sort of the modern digital infrastructure, if you will. A covered article is defined to include information technology, all types of cloud computing services, telecommunications equipment or services, and then critically, the processing of information on federal or non-federal systems that handle CUI, which we've talked about in a previous episode.
All right, so that's the product, but what about the supplier?
Yeah, that's where the statutory definition of source creates exposure for companies. A source is defined as a non-federal supplier or potential supplier of products or services at any tier. So this language imposes a burden on prime contractors to screen their entire downstream supply chain, making their flow-down language vital.
And how hard does a contractor have to look at that point? Is this like an audit requirement?
No. So, and this is a key point. So suppliers have to engage in what's called a reasonable inquiry, which means that they have to uncover information already in that entity's possession about the prohibited articles or the sources. But the definition specifically excludes the need for an internal or a third-party audit. It's like a balance, requiring contractors to check their existing records, their procurement documents, the public listing on SAM.gov, without imposing an economically overwhelming inspection of their entire supply chain components by an outside party.
All right, so all of this is operationalized through the FAR. We're talking about a few FAR clauses, 52.204-28 through 52.204-30.
Yeah, that's right. And when the clause is in the contract, that's what triggers continuous monitoring by the prime, the due diligence requirements, and then their reporting obligations.
Okay, so that outlines all of the new requirements or all of the requirements on the contractors going through their subcontractors. But now let's pivot to the FASC itself that you said was created through this. How does the FASC decide to blacklist a company if they don't follow all of those obligations?
Good question, Ed. So the FASC operates through a very formal deliberative process. It can commence an evaluation based on a referral from any FASC member or from any federal or non-federal sources identifying a risk. The council conducts due diligence using all available information, which can include classified information if necessary. The FASCSA then uses the evaluation criteria found in the CFR.
And what are those? What are those criteria?
The biggest factor is what's called foreign ownership, control, or influence, which should be familiar to our friends if they follow like OFAC and all that stuff, the Office of Foreign Asset Control. But the FASCSA assesses ties between essentially the source's leadership and then any foreign government, especially those identified as foreign adversaries. Foreign ownership standing alone is not enough, say, if the FASCSA thinks that there's sufficient mitigation measures. On the other end, though, if, for example, the foreign country's domestic law compels the entity to cooperate with domestic intelligence services of that foreign country, then that law might be sufficient to permit the exclusion or removal orders by the FASCSA.
Okay, so we're familiar with this, concerns over TikTok, how the Chinese government can require access to all users' data. In the technology acquisition, when it relates to drones, we're worried about what type of ISR information they're sending back to it. So all of that makes sense. Now, you talked about the FASCSA making findings. But what's the difference between an exclusion order and a removal order after they make those determinations?
Yep. So once they make the determinations, the next step is whether or not they issue an order. Two kinds of orders. First one, like you said, is an exclusion order, and that prohibits executive agencies from procuring or extending contracts for the covered article or to a source. The removal order goes further, and it mandates the physical removal of the covered article from executive agency information systems, including systems operated by contractors on behalf of the agency. So an exclusion means that this entity can no longer be a supplier at any tier, whereas a removal means, hey, you've got to take this supplier's product off of our systems, essentially. And recently, which is why we're talking about it, the ODNI ordered that Acronis AG be not only excluded, but also removed from IT systems.
Okay, so that all makes sense. Let's dig into the Acronis case then. So the FASCSA framework dictates 3 issuing authorities. Who are they, and what was the scope of the DNI's order?
You got it, Ellie. So even if the FASCSA, the council itself, recommends the order, there's only 3 individuals who can actually issue that order. The first one is the Secretary of Defense. By statute, now we refer to as the Secretary of War. That person handles all of the Department of War contracts. Second is the Secretary of Homeland Security, which handles all the civilian agencies' contracts. And then the third is the Director of National Intelligence, or the DNI, which handles intelligence community type contracts and systems. The Acronis order was issued by the DNI, meaning its initial binding jurisdiction covered IC executive agency procurement actions, IC information systems, and sensitive compartmented information, or SCI systems. And this order prohibits Acronis AG products and those from all subordinate, subsidiary, or affiliated organizations. So it's pretty broad.
Okay, so in that case with Acronis, it was the IC and the DNI who issued that order. Is that binding on the Department of War and the Department of Homeland Security? All 3 have the authority to do it, but they're not, I would suggest, subsidiary or affiliated organizations. Is that binding on the other organizations?
So not directly. That's a great question, Ed. It's not binding on that per the statute, but because GSA has done some extra work, we are going to implement it throughout the Department of War as well.
So what's next? Once an order is issued, what are the mandatory obligations then under the FAR?
So the contractor faces a dual prohibition. They cannot supply the prohibited product or service to a covered agency, and then they cannot use the prohibited product or service in the performance of their contract. They have a continuous monitoring obligation as well, which means regularly searching SAM.gov for the FASCSA order. And if they discover the use of the prohibited items through their reasonable inquiry that we talked about, they have a mandatory and immediate obligation to report the use to their contracting officer.
So from the contractor's perspective, that's a pretty big financial risk, right? So is there any sort of cost recovery mechanisms if a contractor realizes that this is going on and has to rip or replace a prohibited item mid-contract?
That's an interesting question, Ed, because the clause itself does not guarantee an equitable adjustment. It doesn't talk about sort of that issue. So the contractor is going to have to, if they are interested in seeking recovery, they're going to have to rely on negotiating through their existing contract clauses, like the changes clause, if they've got one. This is the first order, and so we don't really know how the boards of contract appeals would come out on it, whether or not this is already baked in or whether this is in fact a new change which requires that recovery.
Okay, so that's the onus is on the contractor then to find it, but does the government have any enforcement mechanisms? Do they have any way to force the contractor to be looking for this equipment to do anything?
Yeah, Ellie, I think it's just the basic contracting tools, right? So if this is a material term of the contract, so to the extent that the contractor fails to comply with ripping this stuff off their systems, then we just do a termination notice and follow that procedure.
So harkening back to all of the great courses that we teach and take here at the JAG School, I'm remembering our termination and that there are often recourses, or there can be recourses for contractors after we terminate. Are there any for Acronis in this case, or any legal recourses available pursuant to the FASC's decisions?
Interestingly, the FASCSA actually limits judicial review of the order itself. So essentially, it gives an APA-style review, but it requires that the claim be filed directly with the United States Court of Appeals for the D.C. Circuit. That's different than just taking it to the district court, and that's different from taking it, to any real judicial body. It's got to go straight up there. And then the D.C. Circuit's got its own procedural rules with respect to these orders as well. The timeline also is extremely tight. They have to file the appeal of the order within 60 days after receiving notice of the order's issuance. That's a pretty short fuse, and that really is because it's a government priority for security, right? Not prolonged litigation. Interestingly, we don't actually know when the ODNI issued the order itself. All we know is when it was published, which was in September. Acronis could have already had notice of this, and government agencies might have already pulled the plug on the systems that were being used from that entity. We just don't know. We know that it was published recently, though.
This will be interesting to watch to see if any other companies are added to this list. I know the federal supply chain has been under a lot of scrutiny in the last, I would say, 8-10 years, maybe even before. But you've really seen so much in the NDAA, so it's nice that they're doing something more.
Yeah, and it feels like there's a lot going on right now with cybersecurity, and for my foxhole, it feels like a lot of it is speeding up or escalating with respect to all the timelines. And maybe that's because of the success that Israel had last year with its pager operation, but maybe not,
So Jason, in dealing with covered entities for other aspects of what we do, there's a consolidated screening list that you have to consult before engaging in purchasing any commercial items. Does something like that exist for the FASCSA?
Yeah, luckily, Ed, all of these orders, once they're published, live on SAM.gov. So you can just go to the homepage there, you can navigate to the FASCSA orders, and you can see the published list. And right now, there's only one, so it's pretty easy.
So I noticed in the last several NDAAs, Huawei has been specifically called out and prohibited from us buying certain equipment from them. What is the difference between that and then this list with Acronis on it?
So the way I would conceptualize it is that's Congress taking action with respect to a specific entity, and this statute is really Congress giving the executive branch authority to find its own entities or its own supplies that should be prohibited from government contracts. All right, Ed. All right, Ellie. Let me turn the tables.
Off quiz.
And you guys tell me what you learned.
There's a list, and we need to check it twice.
All right, Jason. Make sure I got everything, or at least enough that I can go out and start properly advising my clients. FASCSA, which has been around for a little while, has now published its first orders. This particular order was both an exclusion and a
removal.
There it is. Though the FASC, created under the FASCSA, has the authority to do either an exclusion or a removal. I'm right so far?
You got it.
And from the viewpoint of the contractor, it's their responsibility to make sure all of their subs are complying with the FASCSA.
Not quite right, Ed. So the contractors don't have to comply with the FASCSA. What they have to do is they have to search for those orders and then comply with the clauses that are in their contract that Ellie mentioned earlier.
And those orders are published on sam.gov, you said, correct?
You got it.
There's your list, and check it twice.
Well, I hope this was fun today, Ed, Ellie.
No, Jason, thanks so much for shedding some light on this new Federal Acquisition Supply Chain Security Act. It's been very helpful, and thanks for bringing your knowledge.
Happy to be here.
Thanks for the time.
Thank you for joining us today in this episode of The Far and Beyond. Please make sure to follow us and subscribe on your favorite podcast platform.
We love to hear from our listeners, each and every one of you. Please continue to reach out to us on Facebook and LinkedIn. The information can be found in the show notes from today's episode.
The views expressed today are those of the presenters, not that of the Judge Advocate General's Corps, the Department of the Army, Department of the Air Force, or the Department of War.